As I stated earlier, there have been some difficulties in determining what is considered a disability and thus what is disability discrimination. If we're not clear what is considered a disability and what is not, it's very difficult to then define what is discrimination based on that if we're not clear what the disability is in the first place. So that has been some of the historical challenges. And obviously the amendments to the law have tried to provide more clarity on what is considered to be a disability or not. Some people, employers disqualify a disabled applicant if hiring that person will cause the employer to spend any extra money. And that's not okay, because there has to be a reasonable accommodation. And just the fact that it costs more money is not necessarily undue hardship. So we have to balance that. Regarding accommodations to facilitate hiring, it's unclear how much accommodation is too much, right? Where do you draw the line? So we're always balancing undue hardship and reasonable accommodation, just as we talked about for other laws. That constant tension between the two is very company specific and unique to the situation with the employee and that company. In order to make a prima facie case for disability discrimination under the ADA, the employee has to be able to claim discrimination and prove the following: that the individual is disabled, that they are otherwise qualified for the position, that whether or not an accommodation is required, and if that accommodation is reasonable, so with or without a reasonable accommodation, and that he or she suffered an adverse employment decision such as a termination, demotion, or failure to hire. So basically, they have to be disabled, they have to be otherwise qualified, there has to be an adverse employment decision that was made, and that the accommodation asked for, if assuming that one was even asked for, was reasonable. Right? And again, what is reasonable is really dependent on the job, on the individual, on the organization, but this is the standards for the prima facie case. So it's one thing to say, I asked for a $20 accommodation, or I asked for a $200 accommodation and they refused me. That's one thing. It's very different than saying, well, I want the accommodation, but it'll cost the company $2 million, which again, obviously I'm talking about extreme examples here. The challenges are come at that ambiguity sort of in the middle. You know, is 500 okay? Is 1,000 okay? Would 2,000 be okay? Where does the line get drawn between what is reasonable and what is undue hardship? But for the purpose of the prima facie case, all they need to do is say, I'm disabled, qualified, the accommodation that I asked for was reasonable, and I had an adverse employment decision based on my disability. Disability is defined, as it says here in Exhibit 13.6, under the legislation, a physical or mental impairment that substantially limits one or more major life activities, sometimes referred to in the regulations as an actual disability. You should have a record of a physical or mental impairment that substantially limits a major life activity, or have record of, or when an employer takes an action prohibited by the ADA because of an actual or perceived impairment that is not both transitory and minor, or regarded as transitory and minor. So, the question, of course, is what qualifies? How long should the disability be? Is it temporary? Is it permanent? What does it mean by transitory? What does it mean by, how long is temporary? If it's something is temporary, it's over 2 years. Is that different than something that's temporary and over a month? Right? So we have to be able to differentiate between the two. So now, diving in a little deeper, physical or mental impairment that substantially limits one or more of the major life activities of an individual, or the record of such impairment. For example, if someone had cancer, there's a record of it, but they're in remission now. Are they still considered disabled? It could be, because we don't know how long the impact is on the cancer regardless, right? So if someone may be short of breath, they had cancer, their lung was removed, they're now short of breath, would they still be able to do that job, right? When an employer takes an action prohibited by the ADA because of the actual or perceived impairment that is not both transitory and minor. So that when the action is taken against someone who either is impaired or is perceived to be impaired, and that impairment is not transitory and it's not minor. So it's a major life activity and it has a major impact on that. Determination is based on the effect that the impairment has on the disabled person's life. So what is the impact that disability has on that person's life? And we'll see that in the next few slides. An impairment is considered any physiological disorder or condition affecting one or more of the following body systems: neurological, musculoskeletal, special sense organs, respiratory, speech organs, cardiovascular, reproductive, digestive, genitourinary, hemic and lymphatic, skin and endocrine, or any mental or psychological disorder that substantially limits one's major life activities. The definition doesn't include a definitive list of impairments because it's very difficult to have a comprehensive list of every possible impairment that could exist. Some states have laws that mandate that certain conditions should be considered disabilities, and courts are directed to reach determinations really on a case-by-case basis. So it would be great if we could have one set solid list that these are okay, these are not okay. But it's different for every person because one person with multiple sclerosis might very well be able to do their job with no issues, but another person with multiple sclerosis might be in a wheelchair and require different accommodations. So it's very difficult to have a set of impairments or of issues when it's different for every individual person. Disability is very individualized and it requires an individual case-by-case determination. So what if somebody doesn't have a disability, but people think that they do? The law protects them as well, because obviously, even if they don't have a disability, if they are perceived to be or presumed to be, they are still being discriminated against because of a perceived disability. To establish a prima facie case of discrimination under the ADAAA, plaintiffs have to show that they are disabled, are qualified with or without a reasonable accommodation to perform those functions, and were discriminated against because of their disability. But under the ADA, not the amendment, but the ADA, if you are perceived, you would still have to follow through with the same thing. So it would be perceived to have a disability by the employer and have evidence of that, and then proceed from there. So what are considered major life activities? The ADAAA tried to provide a non-exhaustive list of great examples of major life activities. This includes self-care, manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. It extends to other bodily functions, including your immune system, reproductive system, respiratory and circulatory system, standard cell growth, normal cell growth, and bladder and bowel functions. And so all of these issues are considered a non-exhaustive list of major life activities. So there may be some that we didn't consider that it interferes, then it would need to be determined in the courts whether or not that would be considered a major life activity in the context of the law. The EEOC does include temporary impairments in its definition of impairment. Specific impairments later added to the ADA coverage, which was HIV positive status, irritable bowel syndrome, back injuries, depression, carpal tunnel syndrome. So depression is covered under the ADA, and we have to make accommodations for someone who has a depression disorder. The circuit is split on some impairments. For example, getting along with others from a social perspective. The First Circuit says absolutely no. But the Ninth Circuit argues that interacting with others is an important life activity. So maybe somebody who has Asperger's or autism who struggles to get along with others, there still has to be accommodations made, at least according to the Ninth Circuit, although the First Circuit doesn't necessarily agree with that. When we say something is substantially limited, it means that it's non-trivial, that there's definitely an impact. The ADAAA overruled the Supreme Court's interpretation in the Toyota Motor Manufacturing in Kentucky versus Williams case because they argued that the individual must have an impairment that prevents or severely restricts the individual from doing activities that are of central importance to most daily people's lives. That's what the interpretation was in the Toyota case. But the ADAAA said the question of whether an individual's impairment is a disability under ADA should not demand extensive analysis. And what they're basically arguing is it shouldn't be it shouldn't be difficult for us to determine on a fairly face value. Someone says this is a restrictive to my life, then it shouldn't be that difficult to interpret and to be able to provide accommodations for that. So the ADAAA really tried to say, look, the Supreme Court tried to narrow it, and they're like, nope, we're going to make this, we need to make this easier for people. Multiple individual impairments that together substantially restrict a major life activity may also constitute a disability. So there might be any one individual thing is not a problem, but when you have them in combination, it could be an issue. Temporary is considered less than 6 months, and most correctable impairments can qualify. For example, if you have minor vision problems, that's not included, but some other correctable impairments over time, it may very well be included. The term otherwise qualified means they're able to perform the essential functions of their job. And they may need an accommodation or they may not be, but regardless of that, if the disability is in place, but otherwise they could do the job, maybe a minor accommodation, but the bottom line is if they can fundamentally do that job, then they should be able to do that. The employer may not consider the possibility that the employer applicant will become disabled or unqualified in the future. So you can say, well, in the next 10 years they're going to become unqualified, they're not going to be able to do the job, so therefore I'm not going to hire them. Well, sure, sometimes diseases do progress, and they can get worse over time, but that is explicitly eliminated under the law, all right, because the goal here is what can somebody do right here and right now. When a claim of disability is related to a particular disease, a determination of what is considered to be otherwise qualified is based on the following factors. What is the nature of the disease or how the disease is transmitted? If the disease is transmitted, for example, airborne, like in typhus or in COVID, that is a different situation than someone where you would actually have to have a transfer of bodily fluids like HIV, right? Or some other sexually transmitted diseases. Very different thing. The duration of the risk, for example, how long the carrier is infectious, the severity of the risk, the potential harm to others around them, and the probability that the disease will be transmitted and will cause harm to others. So we have to determine sort of how contagious it is, basically, and whether or not it's going to pose a tremendous risk to others. The level of risk the disabled employee poses to others is crucial in determining if an applicant is qualified. The EEOC does require individualized consideration, as I've said on multiple occasions already, and it's specific and unique to their particular job. Analysis evolves with a medical understanding of the disease, right? Early understanding of HIV and AIDS, we didn't understand how it was transmitted. Now we understand. And same thing, with PTSD and the health risk. It's a workplace safety risk, right, with PTSD. Not that someone has a disease that could be contagious, right? If I have PTSD, you're not going to catch PTSD, right? Because it's about my post-traumatic experience. But I might be violent when I'm in a PTSD episode. I might be unsafe to be around if I have a weapon or if I have something and I'm going to, and I might throw things. So there may be a workplace safety issue at stake with somebody with PTSD. Hepatitis C is highly contagious. Diabetes is not something that is contagious, but it can be, an issue for me if I'm exposed to sugar and certain types of, if I have a suppressed immune system and I might be exposed to something. Episodic conditions like epilepsy, like someone with epilepsy can't be, depending on the extent to which they have epileptic seizures, they may not be allowed to drive. That may be a problem for them.